Thank you. Good afternoon. My name is Douglas Schaefer. I've been a lawyer here in Tacoma for 32 years, and I reside on South 12th and Tyler Street. I've become, within the last year, involved in the Central Neighborhood Council and on its board, and also established its website. And almost all the documents that I'll be referring to in my remarks here are posted on that website. It's cnc-tacoma.com. First, a little bit of history. 23 years ago, in 1988, the City Council adopted billboard regulations that limited the spacing, the density, the buffering of billboards. Essentially the same structure that even remains in place now was adopted in 1988, but the distances have been adjusted since then. But that ordinance 23 years ago, I am confident, rendered many of the billboards in the city non-conforming, but legal because they had been there. But they were 23 years ago non-conforming billboards. The planning department can confirm the number. 1992, the City Council and Planning Commission recognized that the billboard regulations were scattered throughout our code, throughout the zoning ordinance. So they enacted a 1992 ordinance that consolidated all these diverse regulations into a single sign code that consisted of three parts. Part A was definitions, part one was definitions, part two was some other regulations, and part three was identifying the zoning districts in which types of signs would be allowed in part three. Those three parts eventually became what are now the three sections of the current zoning code, 13.06, 521, 522, and 523. But in 1992, they were combined, and it was in 1992 that the current definition of billboard was written in. It was a readjustment of a convoluted definition from the 1988 ordinance, and that definition is significant because that forms the foundation for Clear Channel's constitutional claims. 1996, there was a one-year moratorium on billboards. The ordinance said no billboards shall be allowed within any zoning district in the city of Tacoma. That was July of 1996. It lasted for 1 year. 1 year later, they adopted the 1997 ordinance, which really just adjusted the distances for buffering, spacing, dispersal, size from the 1988 ordinance. Those were just adjusted in 1997. They didn't change the 1992 definition, but they did add the 10-year moratorium. But recognize 1988, 23 years ago, 1996, that moratorium that forbade all billboards was 15 years ago. The 1997 ordinance was 14 years ago. Now, Sun Outdoor Advertising and Ackerley Communications, AK Media, were the only two billboard companies in town. Sun sold out to Lamar in 1998 after the moratorium was enacted. Ackerley sold out to Clear Channel in 2002. Clear Channel then bought Lamar billboards in Tacoma in 2003. So Clear Channel swooped into town as a vulture and bought, probably on a sweetheart deal, all these billboard permits that were going to be phased out under the existing law. And they're, they anger me. The 2007 lawsuit, I want to emphasize, we've done public records requests, and it's clear that negotiations even were suggested and begun before the lawsuit was even filed. There was no attempt by the part of the City of Tacoma attorneys to defend that lawsuit. I reviewed the Clear Channel's complaint. I reviewed this Clear Channel's motion for summary judgment. All of their constitutional arguments rest on a hyper-technical literal reading of the 1992 definition of billboard, which said a billboard is a sign which advertises goods, products, or services not offered on the premises. And so they're saying the 1997 ordinance, since it said any sign, any billboard that is not compliant on the date of this ordinance must be removed in 10 years, and they're saying, well, we don't know what was displayed on those signs on July 22, 1997. They might have been blank. They might have had a non-commercial praise the Lord sign or like Joe sign or something else. Therefore, they wouldn't, under the 1992 definition, be a billboard.
Please wrap up your statements.
The essence of it is the lawsuit could be readily defended if the city even attempted to do it and hired competent counsel to oppose it. Thank you.
Thank you.